Oh, God. All right, I think everybody is back. 2 people. Cool. All right, we're gonna go ahead and get started. It's been 6 minutes. In your book, they talk about 2 specific criminal justice models. And these are relevant in terms of what we just talked about. So what is the purpose of government? How do we define crime? And how are we going to treat crime as a result? So the first model is this idea of crime control. And the overarching philosophy here is that the ends always justify the means. Accused are presumed guilty. They have very few rights. And the focus is on factual guilt. Did the accused commit the crime? What do you think that means? What are the implications there? That's a big one. Absolutely. What else? So if my focus is only on factual guilt, what's the first thing you do if the cops knock on your door? What's that? No, you said it. What was it? It's not a joke though. Do you have a warrant? Yeah, absolutely. So under the crime control model, we don't care about warrants. We are here to see if you did the thing, and how we get that evidence doesn't matter. That is kind of the overarching philosophy of this particular model. And the primary goal is going to be punish and deter crime, with the assumption that punishment is a deterrent. So the other piece here is that, let's say I see you commit a crime, or I believe that you committed a crime, I'm going to put you in jail. Maybe you're not going to get bail because my goal here is to prevent crime no matter what. Or maybe I decided that you did the crime and we're going to hang you, but we're not going to have a trial because we saw you do it, right? So you don't get the right to a trial because I saw you do the thing or whatever. Therefore, you're getting punished, and that's that. We want to stop crime, bam. Other sort of opposite spectrum is due process model, which is that the means must be fair regardless of the ends. So here, maybe I saw you do the thing, but if I can't prove it in trial, it might not matter as much. The accused here are assumed innocence, which is basically what we have in the United States. You get charged with a crime, but you don't actually get convicted until we decide, based on evidence and counter evidence, if you did the thing or if you did the thing the way that it was charged. Maybe you're charged with one thing, but we decide what you did doesn't meet the definition of that thing, so we lower it to a different charge. Here, the focus is on legal guilt. So let's say that you killed someone. Legal guilt, factual guilt, I mean, you killed someone. That's it. End of story. Legal guilt is, okay, when you killed the person, was it manslaughter? Was it murder one or was it murder two? Was it manslaughter one or was it manslaughter two? Every single one of those involved you killing a person, but we're going to look at more nuance. We're going to decide which charge is more accurate based on what happens and less about just the fact that you killed someone. So we're going to have a little more nuance here. And the primary goal is fairness and impartiality. So who defines what's fair? Who gets to decide that? Yeah, in our current system, absolutely. Who picks the judge? Yeah, depending on where you live. We'll talk about this later in the term. Some judges are voted in, some judges are elected, or wow, words, appointed. Thank you. Who gets to do the appointing, so on and so forth. The other idea of who decides what's fair is who writes the laws, who decides the difference between manslaughter one and manslaughter two. That's going to be your legislatures for the most part. But what if I have a Supreme Court case that says, no, this was actually manslaughter two, and now we might have to rewrite or redefine those based on that precedent. So the idea here of fairness is that somebody has to decide, and we get to decide who's making those decisions, what it means to actually be impartial. Can the judge be impartial? If there's a conflict of interest, can the judge be impartial? All that sort of stuff. So here's a fun mental exercise to, all right, read this and then tell me how you plan to obtain the information. What's your plan here? What are you gonna do? How are you gonna find out where Mr. Terrorist is? Anybody? Okay. How do you decide whether or not you get to interrogate the brother? First question would be, why are we detaining the brother? Are we allowed to detain the brother here? Why or why not? Or maybe, and why or why not? What would you need to know before you know if you can detain brother and ask him questions? So, what's that? Okay. So how would we know? Can we detain him if he's not the person we're there to arrest? Or if he's in the home where there's a warrant? Can we detain him if he's not suspected of a crime? Anaya? Doesn't say, right? That's one of the things that you would want to ask. Am I even allowed to be here in the first place? Am I allowed to detain this person? And then am I allowed to interrogate them? Am I arresting this person or am I detaining them? Billy?
With this sort of, so if I'm with the NSA, I was able to then do wiretaps. Do I know a conversation going on in the house?
Yeah.
Do I know if he told his brother something, or it's been clearly defined. There was no attempted secrecy between them.
Well, maybe if he told the brother, that might be some of the evidence that he's going to do it. But does that mean that I can detain the brother and ask questions? Let's make this really fun. Who's going to torture the brother? You laugh, but this is a thing we do, right? It's a real thing that happens. Who votes for torture the brother? No, nobody wants to torture the brother. Okay. Anybody want to threaten to torture the brother? Tell me where your brother is. I'm going to nap your fingers off or waterboard you or whatever the method of choice is these days. No? Okay. Tell me where your brother is or I'm going to go find your kid and kill them. Can I say that? What's that? This is what people do. This is what happens, right? Sharon?
I feel like in a situation you can't be torturing or threatening because
Yeah.
you don't know the thing.
Yeah. And so why is it all violent? What would be a non-violent means of torture? And would that still be okay?
Why can't you give them an option?
I give him the option. Tell me where your brother is or chop your right?
You say, oh, we'll let you go. You tell us if there's later.
Do we do that in less extreme scenarios? Do we ever detain people but not arrest them and say, tell me what you know about your buddy over there so you can leave, right? That's the thing we do. Okay, Billy?
Maybe it could just be so your brother lives here and he's suspected of terrorist action. You could be complicit as an accomplice if you can tell me exactly what's going on with that, his location.
Okay, so I'm threatening to charge him with something. That's true. Probably for some people. Depends on how strongly he feels about the thing, Anaya.
Is there an interrogation question?
Absolutely. There's also a difference between detaining and arresting. He has not been arrested. He has not been charged with a crime. We suspect he knows where our terrorist friend is, but we don't actually know that.
So can you question him and leave?
Assuming that he knows that. Are we obligated to tell him that?
Well,
Not technically. Okay. What if he's not a citizen? Do the same rights apply to him if he's not a citizen? What if he's not a citizen, but it's on US soil? Does the Constitution apply to non-citizens? Nope. Some of it does. There have been some Supreme Court cases that say, yes, it does. Some of it doesn't. Those are the sorts of things that you have to think about here. If I am a national security agency, I am subject to federal law. I might not be subject to state law, but if it's happening on state property, whatever state it is, what if it's happening not on state property? What if I'm down at our nice resort land, Guantanamo Bay, and that's not US soil technically, but maybe it's on a base or something that is owned by the United States. Do I still have to follow the Constitution? Does it apply? I mean, that's what we've done historically, right? That's kind of the route that we've gone. And so those are the sorts of questions that you need to think about. Like if I'm going with a crime control perspective, my goal is to figure out where's Mr. Terrorist no matter what. If I'm going with a due process perspective, I'm going to say, slow down. We need to gather evidence. We need to figure out what's happening. We need to figure out if we can find him without arresting brother. We need to see if brother's also responsible for a crime. And I've only got 3 days to do it.
Is this about that he's working on his own or he's with a larger organization?
Great question. Maybe we can find somebody else who is with Mr. Terrorist. Anaya?
If you're not arrested, you have, I was on.
Nope. There is an interesting Supreme Court case coming up where we might be debating whether or not we have to read Miranda rights at all. So pay attention to that. It'll be fun.
If his brother's like this big terrorist, don't you have probable cause that he knows him?
I don't know. Someone has probably had a family member commit a crime. Are you responsible for that? And again, though, if I'm taking a crime control perspective, I'm going to say, well, maybe you do know, and I'm going to do whatever it takes to find out. So different perspectives. There are kind of pros and cons to each, right? Crime control perspective, hey, look, I saved the embassy. Yay, hooray. Due process is, okay, maybe the embassy gets blown up, a bunch of people die, but I followed the rules and I'm not going to get court-martialed or whatever. So those are the sorts of, and this is obviously a really extreme example, but these are the sorts of perspectives that people take even just with everyday crimes, right? Like searching a vehicle or stop and frisk laws, those kinds of things that are happening pretty regularly stateside towards citizens. And we have to decide which perspective do we want to take. Do we want to do more crime control where we're focused on stopping crime no matter what, or are we worried more about due process and protecting rights, both of the accused and of the victims? Somebody tell me what this says in plain people language. So this particular study basically looked at every country that it could access their law and did this huge analysis and figured out the following. Anybody not in the front row? No? All right, Billy and then Anaya.
Authoritarian system, justice is based on just creating order for people. So it's just like making sure that the law is just followed when it's simple, while liberal democracies have it based off of like genuine good, better for people, as opposed to just like this is legally correct.
Mm-hmm. Yeah. How else could we? Let's simplify it even further.
The first one was more of justice as like a weapon, and more that's what weapons.
Yeah. Yep. Good analogy. If we really, really, really want to kind of oversimplify it, we would say that authoritarian states tend to be more crime control based. So if I am in a country where people are going to try to prevent crime no matter what, that might mean things like what's happening in China, for instance, where we're going to limit certain types of social media because we don't want people doing XYZ, and we're going to monitor their social media. And before they even do XYZ, we're going to go figure that out. We're going to go talk to them or whatever we're going to do. Whereas in a liberal democracy, like the United States, when it was first designed, it's more of a due process model. Like, let's make sure that we are not convicting people incorrectly. Let's make sure we're punishing the correct people while also protecting victims' rights. We need to protect both. We have to balance the rights of the accused with the rights of the victim, which gets complicated. So there's consensus, there's the consensus piece, the Locke and the Hobbes piece that says we've decided what's a crime together. We've decided what crimes against society are, what crimes against people are together. And then there's the conflict theory piece, the Rousseau piece that says, well, we are going to have competing interests no matter what. As long as we have an accused and a victim, those are two competing interests. Those exist regardless. And we have to take both into account. We're going to have a defense and a prosecution. We're going to have somebody who helps make those decisions, but we're not going to automatically go with one or the other. So the compromise is this idea of discretion. Your book talks a lot about this. Formal discretion, somebody had mentioned earlier that there is a judge who gets to decide. The judge has discretionary power. Or in some cases, if somebody decides they want a bench trial instead, then the jury is gonna have that discretion. Or if the jury is split, the judge is gonna have that discretion. Informal discretion is like, if you're an officer and you have to make that decision whether or not a crime has actually happened, whether or not you're gonna arrest the person on the spot, whether or not you need to, attempt to detain other witnesses and ask them questions. Tell me some pros and cons. Tell me good things about discretion and bad things about discretion. Great.
On the like biases, like informal discussion. You don't have like evidence supporting or like hard evidence supporting.
Absolutely. That's a big one. Bias exists all through our criminal justice system. We're going to be talking about that a lot throughout the term. There's lots of research on it. What else? Tell me a good thing about discretion. Tell me a positive. Let's say everyone's heard the example, like what if you get run over by an ambulance and they're on the way to like rescue someone else? Are they supposed to stop and rescue you too? What happens? Can you give me like a criminal justice example along the same lines? Let's say I am an officer, I'm on patrol, I get a call for, let's say, a domestic violence incident or something, and on my way, I see a car crash. I have the discretion whether or not I call someone else to go to the first scene and stop for the second, or depending on what the scene looks like, if I continue on my first call or and call back up for the second. And different jurisdictions have different rules about that to try to eliminate some of that bias. And it doesn't always work. We have to make those sort of decisions. And sometimes we have to make those sort of decisions. And there are always going to be circumstances that come up that the rules don't cover. Has anyone been paying attention to I don't remember what it's called. I want to say the Portland Freedom Project, but that might not be correct. Essentially, it was a fund that was started during the 2020, in the summer of 2020, when the RTT disbanded, the Portland police thing happened, and there were all of the race protests going on, and a fund was started basically to fundraise for paying bail for nonviolent offenders. Has anyone seen any of the issues that have come up with that particular fund? Different organization, but kind of on the right track. So basically what happened is they bailed out somebody who was there for a domestic violence charge and he got out and killed the girl. So whose fault is that? Is it because the person had bail set in the first place? The judge could have chosen to not have bail available. Or is it the fault of this organization that raised all this money to bail this person out? Who had the discretionary power there to say, we're going to bail this person out and not this person, all that kind of stuff. So pay attention to that one in the news because that'll be going somewhere. There are parts of the country that are eliminating bail altogether because there's this concern that wealthier criminals and criminals that have access to more resources can have more freedom than people who don't have the money, which is a concern, right? That's an equity concern. There are systems that are trying to reorganize the bail system and base it entirely on the type of crime and the level of the crime. All right, what if it's my 6th domestic violence charge versus my 1st domestic violence charge? What does that mean? How do they get to 6 versus like, is it gonna happen again? All that kind of stuff. How do we predict that? So tell me when discretion is appropriate during some of the following and by whom. So let's say you are an officer, you are making an arrest or you are deciding whether to make an arrest. When would it be appropriate to use your discretion and when would it be inappropriate? So you're walking down the street and you see somebody doing what appears to be a super obvious drug deal. Like you see the things, right? They're not just like shaking hands or whatever. Is that a thing that you feel like you would always stop and do something or not? Do you have that discretion or do you not have that discretion? Michael, shaking your head. I'm calling you out.
I don't know, I feel like that's all. Stop that.
Okay. Do you get to decide?
That's the decision. Stop.
Mhm.
But
Yeah. Maybe. What if you are not on patrol versus when you are on patrol? Does that matter? Here's my favorite example. I had a coworker, bless her heart, at the state hospital of all places, who was really, really proud of herself for this. She was on the highway and she saw people smoking marijuana in their car. Whatever. We like work with literal murderers and shit. And we're like, okay, fucking hall monitor. She calls her husband who is on patrol and tells her husband who is on patrol about this car where she sees people smoking marijuana on the highway. You already know how I feel about it. What do you think about it? Does the officer, what does he do there, Billy?
it's kind of just like if he, like she didn't know whether he was already on a case or whether he was like seeing, like, say he was on a call for a domestic violence charge. He's probably going to weigh the option and be like, well, I'm not going to stop some dudes that are probably aren't going to be there by the time I get to the location.
Yeah,
And by the time that I get there, they'll probably either hide it or like work out of their house.
yeah. Kobe?
I'm just asking, like, is there some sort of like rule of officers using personal bias?
In some jurisdictions, absolutely. Right? What's your name? I'm sorry. Yeah. Melissa, got it.
I was just gonna say, does he just
Yeah.
or, you know, that means I'm just-
Yeah. Yep. Yeah, it's very inappropriate. And it's a big question. What calls do you respond to? It's super inappropriate. Like, what are you doing? Like we work with that system. You can't just do that. And you should know that you can't just do that. And you're right though, but what if it wasn't his wife? What if it was just some random citizen saying, I saw people smoking marijuana in their car. Like, what do you do there? Sharon?
Well, isn't that situation, like, isn't that legal?
Ooh. You cannot drive while high. Haven't you seen the?
Oh, I thought the way you said it, I thought it was just like they were under an overpass and they were just like.
Okay, well, how'd they get there though, right?
Yeah, probably.
Yeah, it changes the story a little. You guys haven't seen those amazing billboards that have like marijuana puns that like you're obviously gonna laugh at if you're high that they paste everywhere? They're like, don't drive high, and it has like a bunch of arrows pointing up. Like, I don't know who came up with that, but some marketing person somewhere made a lot of money making those. But you have to use your discretion though, right? You have to decide, am I actually gonna go after this thing? And it makes a difference. Like, is there a lot of traffic? Is there not a lot of traffic? What if you choose not to go after it and then that same vehicle gets into a crash and somebody dies and you didn't do the thing? But what if, I mean, that could happen and you hadn't known ahead of time that this particular vehicle had people driving under the influence or presumably driving under the influence. So there are lots of questions there, things to think about. What about with arraignments and conviction? Who gets to decide during the arraignment process? In what ways is discretion a good thing there? Arraignment is your first court hearing where you go and find out what your charges are going to be. Agree?
That's like for when you use like.
Yeah. The other piece that comes up a lot is, am I going to press charges that I think I can actually get a conviction on? Or are they going to laugh at me and throw the case out? conviction, where would you use your discretion? And when would you not?
That like the, see like in a show and they like can't get them on like the big thing, but they hit them on a whole bunch of tiny little charges that add up a whole bunch.
Oh, that would be a plea bargain, which we're gonna get to. Yeah. So I'm deciding whether or not to convict this person. When do I get to decide? Or why do I get to decide? And who gets to decide? What's that?
Jury.
Sometimes, yep. Who else? Can I? Yeah, so the evidence is a big piece here. So the prosecutor is the one bringing the charges and arguing for the conviction, and the person who actually says you're convicted of these charges, you are guilty of these charges, they have to look at the evidence and they have to decide what they think about the evidence. So there's a lot of discretion used there where you have to decide, like you as the jury or you as the judge have to decide, does the evidence actually match the crime that I'm trying to convict them of? And also, what are these other things that come up, right? A lot of people will talk about like, well, I had a gut feeling, which sounds kind of silly, but it's really, really common. And a lot of times those are things that are valid because maybe that gut feeling is actually something that you saw, but maybe didn't write down, or maybe based on your training. Something I see a lot in police reports working with clients is based on my training and experience, I knew that so-and-so was under the influence, or based on my training experience, I knew that so-and-so was showing signs of a mental illness. Or there's that gut feeling of like, okay, I didn't see that guy hit that person, but I can tell that something happened, right? There's also not great things about that, because sometimes our gut feelings are also our biases or our pre-existing beliefs. Alrighty, so some interesting research here. If you end up doing one of your projects on this particular issue, this is a good article to look at. Basically, what they're looking at is here are the times that police specifically can use discretion, or when they are most likely to be able to use discretion. They also found that certain things had a higher impact on whether or not officers utilize discretion versus not. So the hypothesis was that the seriousness of the offense would be a predictor of whether or not they were going to use what would be considered non-coercive actions versus coercive actions. So things like, tell me where your buddy is or else I'm going to arrest you. That's a type of coercion, even though you're not technically arrested yet. Or tell me what your buddy did and I'll make sure the DA gives you lesser charges, which is the thing we do all the time, and which is legal depending on how you do it, whether or not it's considered coercive, but it is considered a type of coercive method. So what they found was that oftentimes the behavior, especially things like a demarcating demeanor, which I think is a lovely way to put it, or disrespect or perceived noncompliance, were more likely to influence whether or not discretion was used rather than the crime itself. So if you ever get in trouble, be nice, basically.
Does like situational that category like
The what?
like prisoner's dilemma, like putting people in different groups.
Oh yeah.
Like does that fit the coercion?
And yes, technically, but coercion is not, when we hear the word coercion, we tend to have this really sort of negative view, but coercive police work is a thing. And we'll talk about that more when we get to police ethics, when it's appropriate, when it's not appropriate, and why. So yeah, absolutely. If you're gonna put people in separate rooms and question them separately, see if the stories line up, all that kind of stuff. Moving on. So in your book, they separate cases into this wedding cake model. I don't know why wedding cake. Not all wedding cakes look this way. Someday this will be totally irrelevant, but that's fine. When we think about different types of charges, would your use of discretion change based on the type of charge? Like, are you more or less likely to use discretion if, say, it's a simple misdemeanor, right? Somebody's like selling his other buddy a dime bag versus like, I just saw someone shoot someone. Somebody laughed. Do dime bags not exist anymore? I'm like old and,
What?
what's that?
Dime bags? No, I know what that, no, I know what that is. I was like,
Okay.
wondering if that's what you said.
Yeah. Fine. Cool, dating myself. So would you use more or less discretion based on the type of charge? Okay, give me an example.
I just going back to like your going to this, all about, marijuana thing, what was it? Like, someone just got stabbed in that car.
Yeah,
And then she calls her. Doing like, those are two different cases, that different tiers on the way here. So I would say that, at least if it was me, personally, I would take a little bit more. Like, oh, they're doing that, let's do that, but
Yeah.
like, they're not gonna get, so I would say the person,
yeah, absolutely. So, big difference, right? A thing that's happening pretty often right now, if you've seen it in the news, is that our law enforcement are being put into spaces where they have to use more discretion based on things like understaffing. So if you call in a property crime, you're probably not going to get somebody to show up. You're going to, that's the reality right now, as opposed to something like a murder. You might get somebody to show up the next day to take a report, or you'll be told, go to our website, submit your report there. That way you can get it for insurance purposes. But if you say, hey, my car got stolen, they're not going to go investigate your stolen car because they just don't have enough staff. So there's going to be a use of discretion there to decide which crimes are we going to investigate, which ones are we going to show up for, all that kind of stuff. Really?
Is that sort of law or legislature in effect in Oregon? Like, is that a federal thing, this one, or is it just a state? Because I know I heard something about that like in Washington, but like,
Depends on the jurisdiction. It's a trend nationally because nationally a lot of police forces are underfunded, understaffed, and very, very burnt out from the COVID stuff. But there's also this trend toward maybe we shouldn't be spending all these resources investigating something like a property crime if that person's not going to end up getting convicted, or if that person's not going to go to prison because maybe we don't think they need to go to prison, should we spend $40,000 of man hours investigating something like this guy's stolen car when really all that person needs is a report so they can get the insurance money? So there's some discretion there too.
so with that, is there legislation backing the property, or is it still like remaining the same?
Not particularly. If you shoot someone because they're trying to steal your car, that's going to go to trial and someone's going to decide whether or not that was okay or not. There are cases where it's been said, yes, that's okay. And there are cases where they've been said, no, that's not okay. It's a car. So it just kind of depends on your jurisdiction. It depends on what else was happening. It depends on the other circumstances. There's all kinds of things happening there. Another problem with this is that, let's say we have somebody trespassing. So this happens a lot, and some of the officers that are going to come and speak to you are going to talk about specific examples with folks facing homelessness. Are we going to send officers and this many $1,000s worth of manpower to go basically talk to somebody because they're trespassing, versus do we need to wait until they actually commit a crime? We're probably, and it's a dilemma, because if we send somebody to talk to them about trespassing, but we're not going to actually arrest because we know it's going to be a huge waste of, like, if we know that that person's not going to get booked into jail anyway, what's the point, right? A lot of people are feeling that way. Or if we know that we're not going to actually charge them. But what if we don't want to wait until something bad happens? What if we don't want to wait for the situation to escalate? So do we do something preemptively, or do we have to wait until a more serious crime has been committed? And there are arguments for both. Neither of those is like really the correct thing to do, because it could go either way. Like, do I want to wait? Like, if this guy's just hanging out sleeping in the stairwell and the property owner's pissed about it, okay, that's a legitimate concern. And if in our current system, at least in Portland, in Multnomah County, we're not going to go arrest that person. But if, let's say there's a confrontation, let's say if the property owner then decides to take it into their own hands, there's a confrontation, somebody gets hurt, then we're going to go do something about it. Could it have been prevented? And we have to decide whether or not we want to be proactive and whether or not we have the resources to be proactive. So it's kind of a thing there. Tell me an example of a quote unquote celebrated case, and I put it in quotes because I think that's a really ridiculous term to, you know, use for things like people getting murdered and stuff, right?
Well, I was gonna say like, some, like, reviews that led to like this.
Mm-hmm. Megan's Law. Yep. Yeah, I don't know why we would call that celebrated. It's just like an odd term. We could say a famous case. I don't know. Maybe that'll be a bonus question on your midterm is give me a better term for those type of cases. The poly class case, that is in your book. So little girl gets kidnapped, raped, tortured, murdered, so on and so forth. The guy that did it had already had several previous convictions that led to the 3 strikes rule in California. Huge case, very high profile case, led to a change in legislation. Change in legislation then had all of these other unintended consequences. So that's an example of a time where we would have a really big case that has, like Billy was saying earlier, some big changes in legislation that are then going to change how we do law. Any others that you can think of? It's in there.
Yeah.
Yep. That's a big one.
Wasn't there something on like stalking law that said
Mhm. Yep. So when we have these really high profile cases, that tends to be the thing that pushes new legislation. Blah, blah, blah. That's not relevant because you already did it. 738, okay. Oh, yeah, fun fact, don't feel well, be nice to me, it's too late. All right, tell me what you read in your book. Is the US legal system based on English common law? Everybody? Yeah, okay, cool. Number 2. Yeah, okay, maybe. In Oregon, robbery and burglary are 2 different things, so maybe. Number 3, this is a fun one. Failure to act, is that a thing here? And does it depend on other things? Okay, what does it depend on?
like if you're an officer, I'm pretty sure there's case law around where there was no promise of protection amongst one person's daughter. It's like a court case that police don't have a immediate right or promise of protection unless they can be charged for not acting.
Yeah, so that's the Tarasoff law. It came out of California, and every single one of you who goes into pretty much any of the fields that you wrote on your cards that you were going into will have to follow that rule. What came out of that was that it wasn't on the law enforcement, it was on the counselor that that person said, you know, I'm going to murder this girl. And whether or not that counselor could break confidentiality to warn the person. Different states have different laws about that. So failure to perform or failure to act, in that particular case, at least in Oregon, that becomes a civil issue. You would lose, like, I would lose my social work license or your counseling license, or if you're an attorney, you would have to go in front of the bar and explain yourself, all that kind of stuff. But it depends, because a normal citizen maybe doesn't have those roles. But if you're in a position of power, if you're a mandatory reporter, you do have those roles. Number 4. Yeah, okay. Number 5. Talk a lot about murder in this chapter. Murder is great. Okay, number 6. This one's easy. Please get this one right. Is rape a victimless crime? Everybody? Thank you. Okay, cool. All right. True. Number 6. Nope. Nope, nope, nope. Doesn't work. Don't do it. You can, but you can come and tell us about it and we will all laugh at you because it doesn't work. And there are situations, say somebody who is adjudicated guilty except insanity, which we do in the state of Oregon, where if it is a result of a mental illness, then that might be the case. So, but it is not the only defense that you have. Oh yeah, more about Latin. Once again, if you use Latin, do it right, because otherwise I'm gonna send you snarky cartoons about it. Everyone knows the difference, what et cetera is, right? Okay, yeah, don't write ECT. Don't do it. I will circle it with a big red pen and draw a very sad face. All right, common law, a brief history. So in your book, they basically, and this stuff is all, it's all in your book. Not a lot of critical stuff here. It's all factual memorization stuff. So basically, we have had common law for a really, really, really long time. This particular code is interesting. This is the oldest one that we have evidence of, and yet the code itself was a reform document. And so it points to earlier law, and we don't know how old that is. What's also interesting about this is that, 5,000 years ago, we're looking at things like social reform and equity, in that case, particularly widows and children, because these were people who were not protected at that time. It also limited powers of the powers that be at that time, so priesthood and landowners. The Mosaic Code, based off the Torah. Very, very, very similar to earlier laws from the region. So this is GFU. I'm assuming most of you have read the Old Testament. Lots of laws, right? Lots and lots and lots and lots and lots and lots of laws. Basically the same thing as the Torah. Some differences. Hasn't been updated as recently. This is the first time that we saw laws against religion or a deity and not just laws against civil society. So we're looking at laws against society versus laws against God, and also laws against individuals, or crimes against individuals, rather. This includes the 10 Commandments. Right? Thou shalt not murder, except when, which we get to later. Not to be confused with Harambe. So this is the first time we see the phrase an eye for an eye, a tooth for a tooth. People have heard that from biblical quotes, however, it wasn't added to the Bible until later. The first site, or the first time we see this, is ancient Babylonian laws. The idea here is that we have a divine right of kings. It comes from the gods to say, here are the rules for society. It was discovered in modern day Iran. It is one of many, many, many tablets that have been discovered of the same. This is the first king to really write all those things down and to say, you have to follow my rules because God said you have to. At least the first that we know of, the first to be discovered. Then we move on to more recent history. So this is where the idea of precedent comes from. For a really, really long time, up until King Henry II, things could be decided by kind of whoever. People in each village decide is in charge. Maybe it's the Lord who owns the land on which that village is built. Maybe it's a magistrate elected by the Lord. Maybe it is a, the king's hand or whoever. Maybe it is the priest who runs that particular area, so on and so forth. This is the first time we have some kind of standardized thing. So we're saying, okay, I'm the king and I'm going to establish a group of judges, and you people, you peasant people, are gonna have to keep your shit together long enough to actually wait for a judge to come along and actually tell you what the law says. Keep in mind, most people are not literate at this point. They're pretty much gonna do whatever the people in charge tell them to, because if not, they're going to starve or get killed or both. And so this is the first time we see any sort of centralized power that says, hey, I'm actually going to have a standardized set of rules, and I'm going to create a judicial system that is nationwide, and they're going to go around and they're going to hold trials. Maybe the magistrate arrests you because you did some messed up thing, and they're going to, you know, once the judge shows up, they're going to take care of that. We also have traveling magistrates at this point too, but this is the first time we have an actual centralized thing that's standardized, right? It's not just up to every single parishioner, that kind of thing. This is again the first time that we have precedence. So if one court decides something, we're going to standardize that across all courts. We're not going to say, well, this court said this, but that court said that, and we don't care. We're going to say, well, these two courts disagree. We're going to have a judge decide which one we're going to go with, and we're going to apply that everywhere. These are your courts in the United States. In Oregon, we have our district courts are typically county-based, but not necessarily. It's really confusing because they are named after various things, various counties and whatnot, but they don't necessarily line up with the counties. And we will look at a map of that here. The district courts, courts of appeal, Supreme Courts. What district court is Oregon in? This is our regional thing, or rather our circuit court, I should say. Do you know what circuit we're in? Number 9. So if you have a case that cannot be decided at the state level, it is going to go to the 9th Circuit. And then if they can't figure it out, it's going to move its way up to federal and then to the Supreme Court. We're going to talk a lot about this process later in the term, so I don't expect you to know all of those details now, because it's very convoluted. But FYI, if you see things in the news that are talking about the 9th Circuit, that's what they're talking about. Federalism. So this is where we wrote our Constitution and decided, well, who is actually going to be in charge of different things? Murder, for instance. Is murder a federal crime or is it a state crime? If you commit a murder, what court are you going to? Anybody? Okay, you should know this. If you plan on murdering somebody, know your shit first. Okay, please. That's what I'm here for. So you're gonna go to circuit court first, and it's gonna be county-based. It's probably gonna go to the state, especially if it's a smaller county. It will rarely be federal unless it happens across state lines or it happens on federal land that isn't owned by the state or under state jurisdiction. It can happen under tribal jurisdiction, and then we're going to spend like 20 years arguing over whether or not it goes to the feds or to the tribe, and then nothing's going to happen, and we're going to forget about it, which is what happens a lot. So we're going to talk about that too. Jurisdiction is really, really, really big. So you should know whether or not something is a federal crime or a state crime. It can also be both. Our Constitution prohibits us from double jeopardy, right? And let's say a smaller court throws it out. You haven't technically been charged or convicted. If it's also a federal crime, they can still take it up. Statutes is just another word for law. In Oregon, we have Oregon Revised Statutes, ORS. You're going to see lots of ORSs. ORS 161.370, blah, blah, blah. Those are our laws here. Codes or ordinances are laws by smaller things like city codes. Is your house up to code? Is your property up to code? Typically something like disorderly conduct, public intoxication, those tend to be city ordinances versus something like I violated this statute by committing a murder. So there's definitely some parallel here based on seriousness, but also jurisdiction. Fun fact. The US Constitution takes precedent over every single state constitution. People argue about this a lot. For instance, there is a measure coming up in November, Measure 112, that looks at removing language from the Oregon Constitution about whether or not people, I remember the exact language. Essentially what we have in the US Constitution that says that you cannot do involuntary servitude or slavery unless a person has been convicted of a crime. That is in the US Constitution. We are voting in November whether or not to take it out of the Oregon Constitution. What happens if it gets removed from the Oregon Constitution? If the US Constitution takes precedence. Yeah, nobody knows, right? We'll see, because we will be, there's like 3 states who have already removed that language from their constitution. Not a lot has happened. It could go to the Supreme Court. If another state says, screw you, Oregon, we don't want to do that. We like having our inmates do stuff for us for free because we're too broke to pay people to do it, which is what we do here. We have your DMV employees tend to be ladies from Coffee Creek and other low security level inmates. A lot of our firefighters in Oregon are inmates. The folks who build your dorm furniture are inmates. They work for Oregon Corrections Enterprises. It's the same furniture we got in our offices at the prison, which is really fun because we got to go pick it out. So on and so forth. So we will see what happens. Either we have to start paying them. We do pay them right now, but they don't get minimum wage. They get some like 30 cents an hour or whatever. We might have to actually start paying them. And we technically don't pay them. We give them points because we have a law. We have a measure from the 90s that say all inmates who are capable have to work. And then we have a second law saying we're not allowed to pay them. And then somebody was like, that's wrong, that's slavery. So instead we give them points. And then at the end of every month, they exchange their points for dollars. It's a whole workaround system thing. But if that measure passes, there will be a conflict between the state constitution and the US Constitution. Anyway, federal statutes are laws enacted by Congress, hence federal. Administrative laws are different than, say, statutes. Administrative laws are things that are regulatory, basically. So OSHA, you might not be committing a crime if you don't follow OSHA or BOLI standards, but you will be subject to an administrative law, and there's probably going to be a fine associated with that. And then federal common law. Common law is basically, maybe it's not in a statute, maybe it hasn't actually been legislated, but we've decided that we're not going to enforce this because of some kind of court case, typically a Supreme Court or US Circuit Court. State laws. So, example here. Let's say you are in Eugene and you are being disorderly. Depending on who catches you, you are either going to break the municipal code of the city of Eugene or you're going to get a state charge. You will not get both because that would be double jeopardy unless one decides to drop it and the other takes it up. We don't typically see this type of charge rise to the state level unless it is happening at the same time as a different crime that rises to state level. Let's say you assault someone and you are disorderly assaulting them as opposed to neatly and orderly assaulting them. You're probably going to get a disorderly conduct in the first degree charge along with your assault charge. Or something like resisting arrest. Really?
What would be the definition of disorderly?
Great question. Let's take a look.
Is that just like when you're doing intoxicated?
That's a discretion thing, right? So ORS 161.023. Let's see if the differences are, if they are the same. 161.023. Oh, come on, show me the things. Oh, this is gonna be bold. It'll tell us if there are A person commits the crime of disorderly conduct in the first degree with intent to cause public inconvenience, annoyance, or alarm, and knowingly creating a risk thereof, blah, blah, blah. Concerning an alleged hazardous substance or an alleged or impending fire, explosion, catastrophe, or other emergency. Stating that the hazardous substance, fire, explosion, catastrophe, or other emergency is located in or upon a court facility or a public building, meaning if you get charged for murder, do not pull the fire alarm. Okay, especially at the courthouse, because that's what that is. And it is a Class A misdemeanor. Yes, pretty much. There's also disorderly conduct in the second degree, third degree, so on and so forth. And those are all going to have different definitions. And you are going to have to decide which one to charge the person with based on which definition it fits. Let's compare that to the municipal code. Hey, look, it's almost the same, but not quite. Makes unreasonable noise. Okay. Disturbs any lawful assembly of persons without lawful authority. That's an interesting one. We see that a lot. We see that on the news a lot. Obstructs vehicular or pedestrian traffic on a public way. So let's say C and D are in contrast. Let's say we're leading a march and we are marching across the street and the people leading the march do this to keep the marchers safe, but it disrupts traffic. But the person who's in the car trying to drive through them is committing C, right? Both of those people would technically be committing disorderly conduct under this law, and you would have to use your discretion to decide which one to charge, or both, or neither. And then down here, don't make up things like fires, crimes, catastrophe, other emergency, etc. A physically offensive, a lot of these are also very purposely vague. What is a physically offensive condition by any act which the person is not licensed or privileged to do, as opposed to physically conditions that you are licensed to do? No idea. Got a lot of really interesting cases out of Eugene at the state hospital, for whatever reason. Criminal law versus civil law. So this is a criminal justice class. We will be talking mostly about criminal law, and you should be aware what civil law is because a lot of times they get confused. This is disputes between private citizens, businesses, governments, totally different court systems, different types of penalties. You're not going to go to prison over a civil issue in the United States at this time because we decided that we don't do that. We no longer have like debt prison, stuff like that. There are also times where there is overlap. We can see things that go from civil law become criminal law. Can anyone give me a current example? Something that happened recently in the Supreme Court. It's a big one. Well, the new case was a civil case, and as a result of that civil case, there are now criminal charges or criminal legislation being enacted based on that civil case. Legislation being written and enforced at the criminal level that previously would have been civil or could have been civil. So there can be one leading to the other. So criminal law is prosecuted by the government. I cannot, as a private citizen, or even as, you know, an officer or whoever, I cannot personally prosecute you. You have to go through the court system, and we have to have the burden of proof beyond a reasonable doubt. This is very much within the due process paradigm. So we can't just say, you did this thing. We have to actually prove it, and we have to have evidence to prove it. And it's our job to find the evidence. Beyond a reasonable doubt. So this is a term that is pretty contentious. It comes up a lot. And it's basically a standard that we decide. Does anybody remember what the book said about it? Beyond a reasonable doubt. Can you assign a number to that maybe compared to civil law? No? Okay. Well, here, let's cheat. In civil law, it doesn't have to be beyond a reasonable doubt. It can be 50% plus a feather was the terminology originally used. So if you're suing you and I'm the judge and I've got my little, judgy scale thing, the brass one that every good lawyer has in their office in 2022, really it's 50% plus a feather. Which way does the scale tip? Versus with criminal law, it has to be beyond a reasonable doubt. It has to be 100%. And here, the burden of proof rests on the plaintiff. It is not up to the judge, the government, anyone else to present the evidence. It is up to the person bringing the civil case. So if you want to sue somebody, it is your job to gather the evidence, you and your attorney that you're paying or whatever, not the judge, not the jury, any of that. Whereas with criminal law, the government, the prosecutor, they have to find the evidence and bring that burden of proof. The penalty here is going to be either financial or some legal remedy. That could be something like some sort of restorative justice. I'm Judge Judy and you screwed up this person's yard. I'm going to sentence you, which isn't even the correct term, but is used a lot because it's TV, to go fix their yard. Nice little handy dandy chart here from your book. Any questions about the difference between those two? 5, I'm losing you. That's okay. All right, Jane and John. Tell me your thoughts and feelings about this situation. So what would make this criminal rather than civil? Go ahead. Yeah, a threat would then become a crime. It's also civil because this is a person-to-person, like a dispute between two parties, or at least that's what the officers in this case have used their discretion to decide. Also, so what else?
Being that it was recently enforced, even if there was some agreement about housing situations or property in which it would be changed, someone else was. There's no argument that it's trespassing because it's still technically.
Yeah, you have to actually go through a process before a person can technically be trespassed for your property. Like I can hang out at your house as long as I want, and you can keep telling me to leave, but until I've been asked a certain number of times, depending on the city, county, which jurisdiction it is, maybe I'm not going to, or will be charged with trespassing. What would make this criminal? So if John made a threat, what else? Yeah, if you broke in, then we're looking at burglary. Really? Okay. What about if during the civil proceedings for the divorce, what if the judge designated certain items as belonging to Jane and said, these are Jane's, they are not yours, John? Could John be charged with something then? He's got a judge's order, he's violating the judge's order. Yep, got lots of nods, Anaya. It could be theft. It would most likely be contempt of court because he's violating a judge's order in that case. Depending on the items though, the officers could decide to charge him with theft. We talked about breaking and using force. What about Aunt Jane? Could Jane be charged for anything? Really?
Refusal to just like I said earlier, it doesn't already property, but the house is now Jane's. She could be squatting.
Maybe. She could also get a contempt of court, right? If the judge has said that those are John's things. What about, what if she keeps calling the police? You can get charged for making false 911 calls. You can get charged with making false information to police, those sorts of things. So whether or not the police are going to actually make that charge again is a discretion issue. Are they bored and have nothing going on? Do they decide that it's a harm or a danger? Is this a couple that they've had to deal with, 30 other times because of domestic violence? There's so many factors that are going to go into whether or not either of these people are actually going to be charged, and why. And that's, that becomes a discretionary issue. And it could easily go from being a civil issue to a criminal issue, depending on all of these other sort of mitigating factors. Like if I've worked with this couple before and I know that there has been a history of domestic violence, maybe I am going to show up and take a report to be on the safe side. That way, when John does show up again and do something dangerous, I can at least say that I took a report and I have the paper trail to follow up, right? Lots of different things that you're going to want to look at here. Or if I know that, let's say that John really, really likes to sue people, maybe I'm going to take a report. That way, when John does go to civil court, there's paperwork backing up whatever, So, two different things here. Substantive law basically says what the act is. Murder 1 is this versus murder 2. Procedural law is how do I get to charge you? How do I get to determine what it is? Procedural law tends to be the technicalities. When you hear that term. The due process stuff. Here's where we get really, really fun. So, guilty mind. In order for us to say that something is a crime, we have to establish both intent and motive. And that might be the difference between something like murder 1 and manslaughter. What was the intent? What was the motive? Did the person have the correct state of mind? If I get into a car accident and somebody dies, and it was because it was really slippery outside, versus I get into a car accident and somebody dies and I was drunk. Those are two very different things, right? One is more likely to get charged with manslaughter than the other. I had a client who, this was on the news, so I'm allowed to talk about it. It's not a HIPAA violation. As she was 18, I believe, and she was driving back from the coast and got charged with manslaughter because of a car accident, was not under the influence. And they said that she was driving recklessly. And she ended up getting sent to the state hospital, unable to aid and assist because she was IDDD. So really lots and lots of questions there. Who gets to decide whether or not this person is truly responsible? Someone has already decided that she's able to have a driver's license despite having this disability. Who gets to decide what driving recklessly was? Nobody else witnessed it. Can we say, driving recklessly to me might be very different than driving recklessly as an 18-year-old. Those roads are really, really windy. What was the weather like? All of those kinds of things. When exactly did she lose control of the vehicle? Can we say that this was purposeful? Was it due to her state of mind? Was it her state of mind during the crime, or is it her overall state of the mind because she's intellectually disabled? Those are a lot of really, really big questions. Motive, not really a motive there. We have to establish motive, like, okay, you chose to get into your vehicle because you were drunk, versus I chose to go to this house to murder this person, versus I was angry and so I murdered them. Those are all different charges. This guy. Sir Anthony Hopkins is the best. No, don't read the answers that are right in front of you. Come on. Sir Anthony Hopkins, do stuff. Really, you're not going to let me end my day with Hannibal? Do stuff, do stuff.
How very thoughtful. Or did Jack Crawford send you for one last meal before you're both booted off the case?
No, I came because I wanted to.
People will say we're in love. Anthrax Island. That was an
We're not
especially
gonna
nice
watch this whole
Dutch
thing.
cherries. Yours?
Everyone's
was
seen Silence of the
good.
Lambs, right? If
Tell
you
you about
haven't, please
poor
go home and
Catherine,
watch it.
though.
It's a great
Tick-tock,
film.
tick-tock, tick-tock.
Your anagrams are showing, Doctor. Louis' friend. Iron sulfide, also known as fool's gold.
Oh, Clarice, your problem is you need to get more fun out of life.
You were telling me the truth back in Baltimore, sir. Please continue now.
I've read the case files, have you? Everything you need to find them is right there in those pages.
And tell me how.
First, principles, Clarice. Simplicity. Read Marcus Aurelius of each particular thing. Ask, what is it in itself? What is its nature? What does he do, this man you see?
He kills
No, that is incidental. What is the first and principal thing he does? What needs does he serve by killing?
anger, social acceptance, and sexual frustration. Sir.
No, he covets. That is his nature. How do we begin to covet, Clarice? Do we seek out things to covet?
So, difference between intent and motive. For those people who have seen the film and or read the books, which you should do because they're great, or if you haven't seen the show is also really great. Mads Mikkelsen is as good as Sir Anthony Hopkins. What is the intent of Buffalo Bill? It's not actually what is there. So that is incidental, as Dr. Lecter says, but what is his intent when he kills the women? Those of you who have read and or seen it. So he's doing it intentionally, right, Billy? Yeah. So we are establishing, we need to have an intent here. He is intentionally killing them for the purpose of skinning them. What is the motive? First of all, what is the motive not? On the screen, because I'm bad at stuff. Anybody? The motive is not anger, social acceptance, or sexual frustration. The motive, we come to learn, is that he covets. He wants the skin. That's a great face you're making. What's that? It is super gross. Welcome to Criminal Justice. We talk about gross stuff. Yeah, sorry. Yeah, it really is a great film. The other thing that's interesting about this film is that despite coming out in the early 90s, you will see a lot of criminal justice issues come up that are still very, very, very relevant. Yeah. So, fun example of, I mean, it's like 8:15, so I have to make it interesting. So we're using Hannibal. The actual act. So the act, the guilty deed in the case of Buffalo Bill is that he kills women and he skins them. That is the act. It is not the motive, it is the act itself, the guilty deed. So again, a voluntary overt act or an intentional failure to act. So earlier we asked about failure to act, it has to be intentional. I chose not to do this because. That's things like the case in the news recently about the little kiddo who starved to death because the parents were not feeding them properly. Mother claimed that it was due to veganism. Doesn't really work. Kiddo died. We will see what happens with that case because there are plenty of ways to, have a vegan diet and still not starve your child. And so we will have to see where that case goes. Is this person mentally ill? Did this person purposely not feed the child? The other children were also undernourished. Will any of the caseworkers involved who didn't do something earlier have any consequences? So that is an example of failure to act. We also then have to establish criminal liability. Did the defendant commit? Did they do the thing? And did they have the intent and the motive that is described in that particular law. So again, difference between murder and manslaughter. One has a totally different motive than the other. So did this person purposely starve her child? Did she not know any better? And then we get to decide, is it possible to not know any better in 2022 when you have lots of information available on how to feed your child, right? Yeah, how much more do we have here? Okay, we have 15 minutes. We're gonna go through a little bit of this. Felonies versus misdemeanors. In Oregon, misdemeanors will get you a year or less, typically in your county jail in which you have been convicted. A felony, you are going to the big boy house for at least a year. Not true for every state, but that is how it is here. Let's talk about times where it could be both. Or neither. Strangulation, ORS 163, what was that? Can you go back? Yeah. All right. All right, strangulation. Tell me, when is this a misdemeanor or a felony, and when? This is ORS 163-187. So first we define it. What is strangulation? Section 2 is great. Legitimate medical or dental procedures or good faith practices of a religious belief. Do not strangle people in the name of Jesus. Technically, you'll get away with it, but it's weird and we will judge you. By we, I mean me. What's that?
Many cases.
Not that I know of, but I'm sure there's a reason they put it in there. My guess would be it's referring specifically to something like you get baptized and they accidentally hold you under a little long because you're blocking the nose or mouth, but it's still a little funny that it's in there. So, misdemeanor or felony? Okay, misdemeanor. When does it become a felony? Can it become a felony? Yeah, so I can strangle you and that's just a misdemeanor, but if I strangle you and a kid sees it, now I'm a felon. I didn't write it, but that's what the law says. This has become a really, really big problem in Oregon because there are lots of people who get strangled and maybe their kid doesn't witness it and that's just a misdemeanor. And now all of a sudden the person who has strangled you is out and about because it's just a misdemeanor, right? It can also be, though, down here, subsection E, maybe they've had previous convictions. If it's the second time they've strangled you, now it's a felony. If you are pregnant and you know, and the person knows that you are pregnant, now it's a felony. So yeah. Or if they strangle you and do something else while they strangle you or prior to strangling you, it can become a felony. If they strangle you and say, when I'm done strangling you, I am going to shoot you using a dangerous or deadly weapon. Now it's a felony. Kobe?
I was like, can somebody just go in the court and say, at any stage,
Sure can.
and it just holds up?
I didn't write it. Presumably, a good jury and or judge is going to say, this person is clearly visibly pregnant, or they're going to show some kind of evidence showing that you knew the person was pregnant. Maybe there's evidence that you got a text message about the pregnancy. Maybe you went to the doctor appointment. You know, maybe you've had a conversation that other people heard. So either way, you have to have beyond a reasonable doubt, and it is going to be on the prosecutor, the state, etc., to present the evidence showing that it's reasonable doubt. So, yeah. What is the punishment? How do you know what the punishment is? Maybe a hint, it's at the very, very bottom. Yes. Look at the sentencing guideline. This is useful because we have a sentencing guideline grid, which we're going to talk about when we get to that part of the term. And it means that every time we want to update sentences, we don't have to rewrite every single law. We can just rewrite the sentencing grid. Billy?
Are we gonna go over how to look over? So, it's a little intimidating.
Yeah, it's a lot of numbers. You're not, for the purpose of this class, you're not expected to know how to do legal citations because this is not a law class. You're expected to know APA citations, and so you might have to learn how to cite ORS 163-187, but you're not expected to know how to do like this is a legal citation. Why is my mouth show? This is a legal citation. If you are writing an opinion, or if you're presenting evidence because you're an attorney, or you're writing an opinion because you're a judge, that's when you need to know that. But for the purpose of this class, you don't need to know that. Mhm.
What's that like squiggly double S?
I don't know what it's called. That's a good question. I will find out.
I looked it up one.
Yeah, it's a pretty squiggly S thing. Really what this is saying is the year the law was written, the page that it's on, and then each time that law was updated and the page of the update that it's on. So sentencing grid first became a thing in 2003, this 577, we updated it again in 2011. So this refers to the updates and all that kind of stuff. But yeah, you're not expected to do all that. We do it when we're actually writing legislation so that we can go back and reference the previous legislation and see how it's changed and evolved over time. Types of crimes. This is a whole other section, so you guys can vote whether you would like to start a section and interrupt it and leave in 5 minutes, do the rest next week, or if you would like to leave 5 minutes early and start from this next week. Option 1. Okay. All right. Bye. Don't strangle anyone, please. I don't think so. Nope. Wait. No. Just what's on the syllabus.
Wait, hold on, I had two specific questions about that last one. What if it was in a sporting event like wrestling? Because that's obviously a
It's not a good faith religious. Great question. I don't know of any cases where that's happened, where it's actually gone to court. But yeah, that's a great question. See you later. Okay.